RA 7080 or Anti-Plunder Act as amended by 7659 is approved on July 12, 1991. So let's discuss how plunder is committed. It is the crime of a public officer committed by amassing wealth for at least 50 million through a series or combination of overt acts, each of which may constitute different offenses. It does not require that each act be proved distinctly from each other. It is enough that these acts show a pattern of accumulation. The series of acts is in the nature of continued crime deemed as only one. So what is the nature of the crime of plunder? It is an heinous crime, thus it is malum in se, mitigating and extenuating circumstance provided by the revised penal code are applied to prosecution under the anti-plunder law. Mens rea or guilty mind is an element of plunder, since the degree of responsibility of the offender is determined by his criminal intent. Degree of participation is also considered. Thus, any person who participates with the said public officer in the commission of an offense contributing to the crime of plunder shall likewise be punished for the same offense. With regards to the constitutionality of the plunder law, the statute punishes for the acts of a public officer in amassing or accumulating ill-gotten wealth of at least 50 million through a series or combination of acts enumerated in its Section 1, Paragraph D.
So what is ill-gotten wealth? Ill-gotten wealth is any asset, property, business enterprise, or material possession of any person acquired by him directly or indirectly through dummies, nominees, agents, subordinates, and or business associates in any combination or series of specific or similar means or schemes. How is ill-gotten wealth acquired? Number 1, it's either through misappropriation, conversion, misuse, or malversation of public funds. Number 2, by receiving directly or indirectly in connection with any government contract or project or by reason of the office or position. Number 3, by the illegal or fraudulent conveyance or disposition of assets. Number 4, by obtaining, receiving, or accepting directly or indirectly in any business enterprise or undertaking. Number 5, by establishing to benefit particular persons or special interests. And number 6, by taking undue advantage of the following to unjustly enrich himself at the expense and to the damage and prejudice of the country and its citizens. It should be noted that this should be committed by a combination or through a series of acts. There should be at least 2 acts, otherwise the accused should be charged within the particular crime committed and not with plunder. A combination means at least 2 acts of a different category, while a series means at least 2 acts of the same category.
Now let's go to the quantum of proof required for plunder law. Since it is a criminal law, the quantum of evidence has always been proof beyond reasonable doubt. In plunder law, what the prosecution needs to prove beyond reasonable doubt is only a number of acts sufficient to form a combination or series which would constitute a pattern and involving an amount of at least 50 million pesos. There is no need to prove each and every other act alleged in the information to have been committed by the accused in furtherance of the overall unlawful scheme or conspiracy to amass, accumulate, or acquire ill-gotten wealth. Now let's go to the court of proper jurisdiction. Prosecutions for plunder are cognizable by the Sandigan Bayan only when the accused is a public official with salary grade 27 or higher. As to the identification of the main plunderer, because plunder is a crime that only a public official can commit by amassing, accumulating, or acquiring ill-gotten wealth, the identification in the information of such public official as the main plunderer among the several individuals thus charged is logically necessary under the law itself.